Morning, everyone. So I'm Allison with Municipal Planning Services, and I've also got Jane here. We're the planning consultant for the Summer Village, and we're working on the Land Use Bylaw project with Council and Administration. So I'll maybe pass it over to Jane here in a second, but I just wanted to add, if you have any technical difficulties, if you can't hear us or anything like that, if you can just send me a message in the chat and I will help you out with any technical difficulties that you might have during the meeting. So Jane, I will pass it over to you.
Thank you, Allison. Good morning, everyone, and thanks for taking the time to attend this meeting this morning. We're going to have, I guess it will be our second meeting with Council and Administration regarding the proposed land use bylaw revision project. At our first meeting, for those of you who were not at that session, we just went over with Council what our understanding of the priorities were for the project and the objectives for the project, with the understanding that we would come back after we had some time to do a preliminary investigation of the existing land use bylaw, amendments to the land use bylaw, and then other applicable bylaws, so that we could have a discussion with Council about areas that through that review and analysis we had identified as being important areas to focus on as we prepare a draft new land use bylaw. And then we also have some questions, I guess, for Council that will help us focus our efforts as we move through that project, or the drafting project part of the project as well. So the meeting today will be a little bit long because there was a lot of material that we reviewed in order to prepare for this session. We did look at, as I mentioned, the existing land use bylaw amendments to the current bylaw, the statutory plan that applies, your municipal development plan. And then we looked more in depth at the current physical situation or environment that affects the Summer Village. And then through some of those things, we also took into consideration the existing structure of your land use bylaw, and then what we were recommending for a revised structure. And I did talk to Council a little bit about that last time we met. And then what we'd like to do, I guess, as we move through the other parts of the meeting is discuss with Council some specific areas in your existing land use bylaw that they're currently part of the bylaw, or that we think are substantial omissions from the existing bylaw that we'd like to include in the new document moving forward. And then we can have a little bit of a discussion about that at the end. Any concerns with the outline or the agenda for today?
Sounds good.
Okay, thank you. So it appears to us that there were two quite significant amendments to the land use bylaw that were done. Amendment 281, 2018 and Amendment 319, 2021. Amendment 281, 2018 amended the land use bylaw to add some definitions for manufactured homes and mobile homes, park models, recreational vehicle storage, single detached dwelling, and telecommunications towers. That amendment was the one, I believe, that was done for the RV park area and golf course redevelopment. So it also created the condominium recreation district and redistricted some of those lands to fit into that district. And then it added some general provisions and special provisions into the document that relate specifically to how we would address recreational vehicles within those areas. So that one's been in effect for a little while. The other amendment that was done is a relatively new one. It is 319, 2021. And it deleted and replaced section 418 of the land use bylaw, which is the recreational vehicles and temporary living accommodation section, and made some changes to how RVs are allowed to be used or stored on lots throughout the Summer Village. Now, Allison, you've got two little asterisks there. Can I get you to elaborate on that for just a second?
Yeah, so I wanted to flag that for us so that we didn't forget to note, when I was double checking the amendment for that, or I guess the text of this amendment, is that I realized it deleted section 4.18 in its entirety. So the additions that were added to that section in the 281 amendment for the CREC district technically got deleted. So those were essentially different provisions for the RVs that would be in that district. So that's just something for us to note going forward. I don't think that was the intention. That was kind of my thought process. So as we go through, what we'll do is we'll double check what those specific provisions were from the 281 amendment, and then just flag those in the new land use bylaw for what we need to keep going forward.
And maybe this would be a good time to just review that briefly with council, because I know that was lots of challenging conversations around RVs within the summer village. But as part of those conversations, and in terms of the purpose of the 319/2021 amendment, the intention was not to delete the provisions that were supposed to apply specifically to the condominium recreation district, was it?
No, not in my mind.
Okay,
Help me here.
that's what we thought too. Sorry, Graham.
No, I also believe that may have been an error.
Okay.
Yeah, it wasn't my intention either.
Okay, so we will add them back in.
Yeah.
Thank you.
Yeah, okay, that's what we thought too.
Yeah.
Okay, cool. So those are the two major amendments that we'll be looking at. I know that the 2021 amendment is relatively new, but I also know it was a controversial discussion and issue within the Summer Village. And so even though it is something that you've looked at, quite recently, I think it's something that we should maybe have another look at as we're moving through this project too, just to make sure that the community is aware of what's being proposed moving forward. Is that okay with council too?
Yep, I think so.
Okay, excellent. And for those of you in the audience, I guess today, the reason that we're doing this the way that we are this time is because it's important to council and administration that this process be an open and transparent process, and that the community have lots of opportunity to provide us with your feedback as we move through this. It'll probably take about a year to do the work. What we might do moving forward is just make sure that our meetings are broadcast either to a YouTube channel or something like that, so that you do have the ability to take part or to listen in to these conversations and provide us with your input after the meetings as well. As part of this program too, this project, there will be opportunities for direct engagement as well. These meetings are not that. However, we do want to know if you have comments, but there will be an open house as well as part of this, and we will provide newsletter updates and those things. And Allison and I and administration will be available throughout the duration of the project if you have any additional questions, so that you can contact us and we can work with you to make sure that everybody is informed and everybody has the opportunity to provide their input to council and administration prior to any decisions being made. So the other bylaws that we looked at, because even though they're not part of the land use bylaw directly, they do have an impact on a relationship between matters that are also addressed in the land use bylaw, are your drainage regulation bylaw, which is a golden oldie. It's from 1989. Your sewage bylaw and the sewage bylaw amendment, your noise bylaw, your nuisance, unsightly, and untidy bylaw, and your animal control bylaw. The drainage regulation bylaw is an interesting one, and I think maybe as one of the things that we do as an implementation item following the completion of the land use bylaw might just be to give you a list of things that you might want to have a look at in some of these bylaws that we reviewed, just to ensure consistency between these bylaws and your land use bylaw, because there's a couple of areas in here where we think there might be some revisions necessary just to tidy those ones up a little bit too, and make sure that what we put in the land use bylaw will be consistent with these other bylaws that you have. I always check for definitions in other bylaws because we don't need you to have multiple definitions of noise or nuisance or unsightly that are inconsistent with each other. So that's one of the reasons we look at these things. The other reason we look at, say, your animal control bylaw is often we will in a land use bylaw define kennel, and the definition of kennel is often how many dogs are considered to be part of a kennel is that number of dogs that would exceed the number of dogs you're allowed to have on a lot. So we're just clarifying the difference between the different types of uses. So it would be anything greater than 3. The other bylaws that we looked at were your development authority bylaw, your subdivision authority bylaw, and your use of public lands bylaw. And the only one that I think we might need to have a look at, just to provide some clarification, or we may need to address more specifically in the land use bylaw, is your development authority bylaw. Because this bylaw, instead of establishing the position of development authority and indicating the responsibilities and manner in which the development authority should be appointed, just appoints your development authority. So there's two ways we can deal with that. One of them is we can revise your development authority bylaw. The other way is that we can just establish the position of development authority and indicate the responsibilities and manner in which the development authority will be right in your land use bylaw. And that might be the easier thing to do. I'm not sure. I can have a chat if you'd like, counsel, with administration and just figure out the easiest way to tidy that one up for you. But we did flag that that one needs to be addressed in one way or another. And it's the easiest thing might be to just fold it into your land use bylaw. So we'll deal with administration to come up with the best solution for that so that everything is all neat and tidy and clear in relation to those particular other bylaws. Does that sound okay?
Yeah. In terms of drainage, Jane, I guess my concern there is that we have quite a few vacant lots, right? And existing structures, residents beside perhaps a vacant lot, and to ensure, like, are we covered in terms of making sure that one lot isn't flooding the other lot, that kind of thing?
I'd like to fold the drainage and lot grading provisions right into your land use bylaw.
Okay.
So they're part of that instead of in this other bylaw, because I suspect that in the old, 1980s bylaw, that's not actually being looked at by the development officer when development permit decisions are being issued. So I think it's really important to have those provisions in your land use bylaw because they're so impactful, not only on neighbors, municipal infrastructure, but also the lake. I just think it's in the wrong place now.
Okay.
And that would have been established pre-Municipal Government Act, right? So might have been something that was done under previous legislation too.
Okay.
So we'll look at it, and if it's good stuff, we'll just fold it in. And if we can make it better, then we'll add a whole new section to your land use bylaw, and I'll flag that for you guys in particular when we come back and review the draft document.
Super.
I have a question.
Yeah.
In regards to the animal control bylaw, is there a spot coming up? We're going to go a little more in depth in that it should cover, I think, more than dogs. At the very least, it should cover cats, and I don't know about other large animals as well. People keep everything right down to pigs now as household pets.
No.
We don't have a limit on any of that.
We're not going to dive too deep into your animal control bylaw because it should be a separate bylaw from your land use bylaw. If it's something that you as council would like to revisit, we can make a note of that and we'll just identify that as one of the implementation items for you. Where it overlaps with the land use bylaw is when we're working on a definition of kennel.
Okay.
Does that make sense?
Yes. Yes.
Okay. Yeah. So and like when I bring the land use bylaw back to you, I'll flag that definition too. Because maybe, if you could have 3 dogs, but you could have 2 cats too, it might create we just have to be really careful about that. I don't want to do something in your land use bylaw that's inconsistent with what you're going to do in your animal control bylaw.
Okay.
People will be unhappy with me.
Jane, one thing that we've had come up in a couple other communities in the last year is chickens and the housing and farming of chickens in summer villages. And I guess the discussion in the other communities was to put it in the land use bylaw. So is that something that should come here, or would you suggest that stays in the animal one?
Oh boy. I think
Or
it's
think about that. Don't have to answer it today, but let's just make sure we have that conversation that if it should be here, we do talk about it here.
okay. Chickens
If in the end,
right?
council wants it.
Jane, there is a slide later on in the presentation about the keeping of animals and livestock where I flagged that, so we can
talk about that then.
Yeah,
Sounds
because I believe that was one of the items that council had identified that they wanted to talk about that Heather said to me. So I made sure that that got
Yeah.
into the presentation.
I think
Thank you, Allison.
captured, yeah, you captured the bees too, I think, in
Yes,
your
yes,
slide. Yeah.
Okay, so then some of the other things that we looked at were your municipal development plan, because you have a new municipal development plan, just to make sure that the direction in the land use bylaw, the way that the MDP and the land use bylaw should work together is that the land use bylaw should be the tool that you use to implement the vision and goals in your municipal development plan. So that's how they should be consistent with one another, is the land use bylaw is the rule book or the tools that you use to create the vision that you've identified in your MDP. So we'll make sure as we move through that we're showing the relationship between those goals and objectives in your MDP and what we're doing in the land use bylaw, so you can see the direct relationship between the two. You don't have an intermunicipal development plan, so we don't need to be aware of that moving forward. The Summer Village and the county agreed that there wasn't a great deal of value in having that at this time. So just the MDP that we need to be consistent with. And you're a little summer village, not terribly complicated in terms of land uses. So your MDP is not terribly complicated either. I don't think we're going to have any challenges with that. All right, so then the next thing that we look at as we try to identify potential hazard areas and ensure that moving forward, the regulations in your land use bylaw are informed by best practices for watershed management planning. And it's something that our firm's been, thinks is really important for development that's occurring, I guess, near a lake or in a lake environment. And I've found working with rural areas and small communities throughout Alberta that the most beautiful places to develop are often also the most complicated places to develop, because they have the features that make them beautiful are also in many cases features that we would consider hazard lands because they can move or they can flood or, you know, all of those things. But we're also stewards of some of those areas too, because they're so ecologically important to us. So our water resources, which are why summer villages are where they are, we have a responsibility to ensure that we're not negatively impacting too, both from the perspective of ensuring the ecological integrity of those areas, but also protecting our own property values too, right? The lake, it gets really icky. It's not as nice a place to be. So. Some of the things that we looked at and will include regulations and also application requirements to address are identifying areas prone to flooding seasonally, high water table, environmentally sensitive areas, which I think I talked to you about before. Those are areas that have been identified by the province in their data as environmentally sensitive. We can expand upon that if you know things that the province does not, and we can talk about that once we've got the draft together and some of that mapping. And then ensuring that the land use bylaw addresses the village's obligations under other provincial acts and regulations. And the last bit there is specific requirements need to be identified for development permit applications that will help us ensure that, you know, if subdivision is proposed, which can happen in your summer village, or if development permit applications are coming in, the development officer, the subdivision authority and council, if there's a land use bylaw amendment involved in that process, have the information that you need to feel confident about the decision you're being asked to make. And we have, you know, there's always a bit of a challenge, I guess, working with developers. And that can be someone who wants to put up a garage, or it can be someone who wants to do a multi-lot subdivision, in making sure that we're really clear about what the triggers are for asking for additional information with those applications. And we're consistently applying, I guess, those triggers and requirements. Because anytime you ask for a little bit more with an application, essentially what you're doing is asking somebody to spend a little bit of money, a little bit more money up front with their application, with no guarantee that the application is going to be approved. So part of what we need to do, I think, through this process is identify really clearly what the types of things are that the municipality may need to ask for, and just clarify why we need to ask for additional information sometimes, and what that additional information would be. So the bylaw itself is a little bit more transparent, and it's easier for people when they're thinking about or planning their own redevelopment of their properties to know what those additional costs might be, so they can factor them into their planning and design. So I think that's somewhere that in our older land use bylaws, we haven't done that very well. And then it's difficult for community members or developers to understand where some of these asks are coming from. So that's one of the things that we'd like to focus on fixing the beginning of the document, is just providing more of that information about process and requirements, so that it's a little bit clearer for people too. And I think that's a learning thing. I know that the lawyers have also recommended that we do that, so that people are entitled to that information up front, and then they can see too and make sure, I guess it acts as a bit of a system of checks and balances to make sure that we're doing things administratively the way that we're supposed to be too. So all of this stuff is really boring, really boring, but it's also really important. And we'll work with administration on some of those pieces, and then we'll talk with council about that too when we got that together. Okay. So your current land use bylaw is not a terribly sophisticated land use bylaw, and you're not a huge municipality. So in some regards that makes sense, but there are things that we have, I guess, learned over the years that we need to include in land use bylaws, even land use bylaws for small communities, to make sure that you have sufficient direction within the document to be able to clearly and consistently interpret the provisions in the document and regulate the things that you need to in order to, prevent unforeseen negative impacts on adjacent properties as a result of what we have approved, either because we have to, or approved and not had enough information to adequately assess and determine what those potential negative impacts could be. And I think one of the ones that we're seeing most often in many lake communities in particular, but we also see it in towns and villages where the subdivisions were done pre-requirements for lot grading and drainage plans, stormwater management plans as part of the overall design and subdivision. So that as new development and redevelopment happens, it is negatively impacting neighbors. And that's, lot elevations change, new construction is much bigger than old construction, and we're not directing water the way that we should. So the way that we deal with lot grading and drainage, requirements for trying to encourage the retention of vegetation, especially on lake lots, those sorts of things were not addressed in great detail in your land use bylaw. And in order to prevent the types of issues that we know are occurring, we'd like to handle those or address those in much greater detail in this document. Is that okay with council?
It's good for me.
Yeah, sounds good.
Yes.
Okay, awesome. It's sort of retroactively going back in and trying to fix, but we can do that. And I think it's the right thing to do to try and make sure that as the new redevelopment occurs, we're not creating a mess for you. So the new document is got more sections in it than the previous. I think the previous document did deal in some regards with many of these matters. They were just all mashed together in the front bits. I find it easier to find the things I'm looking for if we separate them out into different sections. So it will be a bigger, longer document, but most of the additions will be to the front end. So interpretation, definition sections, and then just providing additional clarification about what some of those administrative processes are. The rest of the stuff should stay pretty straightforward, except in those areas where we're touching on, watershed management, lot grading, landscaping, retention of vegetation, those things that are new to your document. So in relation to definitions, what we always do when we're going through these projects is we review the list of uses that are identified in the districts in your land use bylaw, and we make sure that they are all defined, because often they are not. And then it's difficult to know exactly what it is that's being approved or not approved. And then we'll go through and add definitions for any terms that are missing a definition. And then we'll also do a sweep through the document too, to make sure that the terminology that's used throughout the document is consistent and that it relates back to those defined terms. The last thing that we like to do with the definitions too is, where we can, is add some diagrams to just clarify what it is that we mean. And any of you are lawyers. The lawyers don't love our diagrams, but the lawyers don't have to work with somebody who doesn't do development every day to try and explain what a rear yard is or a front yard is on a lake lot, or what we mean when we're talking about adjacent land. These are really useful tools to work with community members who are unfamiliar with the kind of language that we use in a land use bylaw, to explain what it is that we mean and what it is that we're doing and what our expectations are. So we find them very valuable and useful tools. And so we do tend to add a fair number of diagrams. Is council okay with that?
No, that's, I think, very important.
Yeah, more than okay with me. I lived with a lawyer and I know how I know how the language gets mixed up.
Excellent. Thank you. So these are just a couple examples of the types of diagrams that we like to include, just because these are terms that we know mean something quite different in the context of a land use bylaw than they do in other situations, and quite honestly can be different in some regards between land use bylaws. So we have to be a little bit careful and clear about what it means in the context of your document. One of the examples, I guess, would be for a lakefront lot. Even between the different professionals that work with summer villages or municipalities, the words lakefront lot means something different. So in the context of a land use bylaw, a lakefront lot is a lot that is or would be touching the bed and shore of the lake, if not for, and then there's a couple of qualifiers. One of them is a reserve lot, often also a road is included. And from our, we still consider all of those things to be lakefront lots, even if the land itself does not directly abut the bed and shore of the lake. I know that has been confusing in some municipalities. So if we can define that and identify what it is, because it affects setbacks, then that makes it a little bit easier for people. Okay. So Alice, in this slide, these are terms that we'd like to add that are not currently in the land use bylaw. Is that correct?
Yeah, with the exception of boathouse. My apologies. There is currently a definition of boathouse in the land use bylaw.
So,
but yes, and Jane, if you maybe I can just explain quickly if that's helpful. Yeah, so most of these definitions that we are proposing to add relate back to what Jane was saying earlier about incorporating watershed management planning best practices and including regulations to help us address hazard areas within the summer village. So some of these things are already addressed in the land use bylaw, but we want to expand on them and then make sure that they're clearly defined, because it makes the interpretation of the land use bylaw much easier, not only for administration, but for your residents and for development proponents as well.
And these are terms that we, over the last couple of years, as we've been writing regulations to address, stripping and grading and landscaping requirements, we've gone back and forth with a number of councils, and terms that they have got stuck on as it pertains to the regulations. We've been working to try and define and refine to make it a little bit clearer, so that the regulations are as clear as they can be once we implement the land use bylaws. So it is a lot of additional definitions, but I feel like land use bylaws should have a lot of definitions. If we're using terms to tell people what they can and cannot do in a lot, then we should very, very clearly be able to define and explain to them what it is that we're talking about and what we're regulating. So this is, I guess, the biggest change to your land use bylaw will likely be the definition section, because there will be more defined terms. Are you okay with that?
Yes.
Okay.
Yes.
Thank you. And we tell all of this to you up front, because when you get the document back, you're going to go, what happened? It's so big. And it's not, there isn't a whole lot of additional regulation, but there is a whole lot of additional defined terms that affect some new regulations. Okay, and Allison did flag a couple of those terms that we'll come back and talk about as we move through. So you have a section that talks about acts, authorities, and agencies, and that's just explaining who the different decision makers are and what decisions they make in relation to Part 17 of the Municipal Government Act and the Land Use Bylaw. And so we'll go through that section and ensure that the references to the MGA are correct, where they're included in the document, and then we'll update the authorities and agencies section to align with existing legislation. And Wendy and Heather, I'll talk to you about that development authority bylaw and how we need to address that. But this will be the section that if we're going to establish perhaps a development authority through your land use bylaw instead of that other bylaw, this is where we would put it.
Jane, one thing I had missed adding to this slide is that currently the land use bylaw establishes a municipal planning commission, but I don't believe that there's an MPC bylaw, or does the Summer Village have an MPC? Wendy or Heather?
Is Tony the all-powerful laws, or do some decisions come to council?
Sorry, what was the question?
Does the Summer Village have an MPC for discretionary use development permit decisions, or are all development permits issued by Tony?
Well, we have our direct control that comes to council.
Yep.
I
Other than
think
those,
other than that, it's Tony.
it's Tony. Okay, so there's an inconsistency too right now between the way that the development authority is set up in the land use bylaw and your development authority bylaw, and that I can see how that would have happened. So in your existing land use bylaw, it says right now in the definition of development authority that the development authority will be established by as pursuant to the Municipal Government Act. It may include one or more of the following: a development officer, MPC, council, or any other person or organization. And then there are provisions in the land use bylaw for an MPC, but you haven't got an MPC. So actually, this is probably something we should talk about right now, because I guess we need to know whether or not you want to have a municipal planning commission. Does council know what that is?
Jane, if I could jump in here, during our organizational meeting, we appoint council as MPC each year.
Okay.
Oh.
But council hasn't been making decisions about discretionary use development permits?
I guess that would be a question for Tony. Wendy, are you aware?
I can't think of anything that's come to council that would be a discretionary, but I guess, Jane, I can't answer you that. Would be a question. We'd have to look into it more.
Yeah.
Okay. Well, let's just do this as on a going forward kind of basis. So council has been appointed as the Municipal Planning Commission. Where municipalities have a Municipal Planning Commission, the Municipal Planning Commission's purpose really is to make decisions about certain types of development permits. And it's different than, say, for your direct control district, even though it's the same three people that are making the decision. If you are making a decision about a development permit MPC, the development permit decision is still appealable. If you make a decision about a development permit as council, the decision isn't appealable because decisions of council are final, right? Except to Court of Appeal. So, or sorry, excuse me, not even to Court of Appeal. So in your land use bylaw, you have set it up so that there is a Municipal Planning Commission who can make decisions about certain types of permits. Do you have that section open, Allison? Normally, the way that it would look is that if you have an MPC, the MPC would hear and make decisions about development permits for discretionary uses or for a permitted use where the applicant has requested a variance of a certain kind. Sometimes the development officer will be allowed to say grant a variance of up to 15% or something without taking it to MPC, but anything that would exceed that has to come to MPC. Does council? Oh,
Jane,
sorry,
sorry, it's 20% a variance is supposed to go to MPC. Sorry, greater than a 20% variance is supposed to go to MPC as it's currently worded in the bylaw.
Okay. So is this something that council wants to be involved in at all, or would you prefer the development authority to be your development officer in all instances other than your direct control district?
It's Liz. I think for me, one concern about having it be council is that the room for inconsistency in decisions when re-elections occur is a troubling part of, for instance, this council could make a decision that affects a developer, an individual developer. And then next council that comes in could reverse that if that was the case, right?
If they reapplied, they could issue a different decision. That is true.
That concerns me a little.
Yeah, I think I have been trying to, over the last little while, discourage councils from being directly involved in the administering of the land use bylaw. I think it's a little bit cleaner if council's responsibility is to do projects like this, to create land use bylaws, and then to be the folks that people come to if they want to apply to amend the land use bylaw to change things. So ultimately, council is in charge of the land use bylaw. But once those rules are established, the administering of it, I think that's an administrative function, and that should be handled through administration or through, you know, whoever you appoint to do it. So I think we're your subdivision authority. And Tony has been your development officer. And some municipalities that works really well for that sort of division of labor, keeping the different functions quite separate. And I like it. I think it's cleaner. But some councils just like to be really involved too. So it's entirely up to you, but I guess however you would like to do it will change how we write this first few sections of your land use bylaw. So if you have a feeling for what you would like that to be, it would be helpful for us to know.
Well, I think, you know, I agree with you, Jane, that, you know, we're the policymakers, not the administrators. So I think, you know, as I'm thinking out loud, I think the separation would probably be the better way to go. But
I would have to agree with that, I think it should be arm's length, and that has come in useful at times in the past. However, I don't know, what is your suggestion that if there is some room for discussion on a particular project, where would it go after Tony?
So technically it should never come to council unless there's a discussion about a particular item like we've had in the past, say negotiating a development agreement. That is a council discussion because it affects money, right? How much security you're going to have, those sorts of things. But if it's just reviewing and making a decision about a proposed development, all of the guidelines for that are in the land use bylaw. And so when the development officer is going through that process, technically all they should be doing is implementing what you have established through your land use bylaw. And so that really should never come to council. It's just that those questions about money or standards for construction, for those sorts of things, those need to come back to council if someone is asking for a lesser or a different standard, because those are different.
And what you are saying sounds much cleaner to me. I think the comment about policy versus administration is very central here.
Yeah, I like that. I think it makes it clear for people too, you know, when they're coming and asking council, these are the things that council can address, and then these other things are just, they're outside of the purview of council. You've delegated your authority to the development authority, and the development authority in that case then would be the development officer. So we will rewrite this section to no longer reference a municipal planning commission, and I think probably make it a little bit clearer how this process maybe has been being carried out over the last little while anyway. I think that sounds good. And then we'll just establish the development authority through the land use bylaw. And then I'll follow up with you, Wendy and Heather, about how to address your development authority bylaw. Wendy and Heather, do you have any concerns with that?
I do not.
Okay, sounds good. And I'll let Tony know that we're looking at doing this. All right. So then we get into the actual administrative bits. So there is a section in your land use bylaw right now that is development not requiring a permit. Any development that's proposed within the municipality that is not specifically identified in this section as not requiring a permit needs a development permit. You have in your land use bylaw identified permanent, or you allow portable accessory buildings without a development permit. Are they of a certain size, Allison? Up to 100 square feet?
Yes, let me hang on, Jay. I can check that for you right now in my notes, because I can't recall off the top of my head, but just give me 1 second.
But it is interesting that your land use bylaw, that there's one of the qualifiers for not requiring the permit is that the accessory building be portable.
Yes. Do you want me? So Jane, it is a portable garden or tool shed not on a fixed foundation that is less than 100 square feet in area and is less than 8.2 feet in height.
Okay, so I think that works. One of the things that I wanted council to think about is whether or not you want to limit the number of accessory buildings that meet those qualifiers that you would allow without a permit. I don't know if that's something that you're experiencing within your municipality. Some of the summer villages we've been working with, in order to circumvent the need for a permit, they've been finding that people are just bringing on like 4 these little tiny structures instead of building a proper structure, because then they would have to go through this additional process. I think that it might be a good idea to limit the number of portable accessory buildings that you allow without a permit.
I agree.
Okay, it's a loophole that I had never considered before, but we have seen in the last little while. So that's something that we can clarify in those provisions. Then the next one there is, we think it might be valuable to clarify when retaining walls are allowed without a permit, and then what the trigger would be for requiring a development permit for a retaining wall, because there are some really big retaining walls that we have seen go in different locations, especially on those beautiful lake lots. And then some of the issues we've had with them have been, unexpected negative consequences affecting the adjacent property because of the really big retaining wall and how that impacts drainage, or retaining walls being built into road rights of way. That's the other thing that we've seen happening too. People don't necessarily know where their front property boundary ends and where the road begins. It's not where the road surface is, right? It tends to be set back a little ways. So we were going to ask council if you had any concerns with us clarifying that retaining walls of up to a certain height would be allowed without a development permit, but once they would require building and safety codes approvals for them or engineered drawings, and they probably should have a development permit too.
Good idea.
Yeah, I think so too. One question I would have about that is how would that affect existing structures that that maybe don't meet whatever we set as the new standard?
Anything that is there already that was built, I guess, lawfully. So it didn't require a permit, or it met the requirements in your existing land use bylaw. Those things carry forward as legal non-conforming developments or uses. So we don't have any concerns with them. Changes to the land use bylaw do not retroactively go back and affect those things. Where developments, I guess, that occurred with a permit or were unregulated in your land use bylaw, where they could be affected is if in the future a landowner decides they want to make changes to them.
Yes.
And the provisions in the new land use bylaw will apply. The rules of the day apply. But as long as they don't do anything to them, they're fine.
Thank you.
Thank you. It's a good
Do
question.
you have an idea of what that height would be without the permit?
I used to remember, Graham. Allison, do you remember? You're muted, Allison.
I was saying that I want to say, and I quite literally do want to say, I think, I believe it's 1.2 meters. I just checked what we did in Island Lake, Jane, and that's what we identified. So, and I had a recent conversation with Brad about this because we were talking about it in the context of another land use bylaw as well. So I believe it is 1.2 meters, but we will verify that, and then I'll capture that in the meeting minutes and I'll flag that for you.
Yeah, that's almost 4 feet. That's pretty high.
Yeah.
Wow.
You can get retaining wall blocks just commercially, like at Home Depot and stuff, that are pre-engineered up to, I think it's about that as well. It's about 4 feet, I think.
Oh,
They
That makes
are
sense.
engineered. That's what I used when I built my house as well. And I'm up to the highest point. It's about 4 feet. That's as high as I could go with the pre-engineered block.
Yeah, that makes sense.
Jane, back to the accessory building. We're wanting to open that up for vacant lots as well, right? I don't know if that's further on or.
I have that flagged later on to talk about.
Okay, thank you.
I think we're almost there.
Okay.
One of the other things we wanted to ask you about was what types of home occupations, if you have any within the Summer Village that you're aware of, that we need to make sure that we're continuing to provide for. Quite often, land use bylaws will have provisions in them for home-based business or home occupation. The way that we write them normally is we distinguish between 2 different scales of impact, I guess, or size of business for different types of home occupations. A minor home occupation and a major home occupation. Minor home occupation generally characterized as those types of home-based businesses where you don't have an off-site employee that comes into your house, it's just you. There's a maximum number of visits or customers that can come to your house per day, and I think it's quite low. It's like 2. You can't have an external sign. So really there's supposed to be those types of businesses that would maybe occur within a house or a cottage that your neighbors wouldn't even know you were doing. There would be no obvious off-site impact from them. And the way that people are working now, I think there's probably going to be more and more of that. And we need to make sure we're providing for you to be able to work from home. Or from the cottage or wherever. The major home occupations are a little bit more impactful on a neighbor because there could be more visits to the dwelling. So, I don't know. What would be a good example? Sometimes a hairdresser, someone who has a chair in their house, or someone who, as a side business, grooms dogs or something like that. So there are a higher number of visits allowed to the site per day or per week, and then could have an off-site employee that comes in and assists with whatever the business is. But there's a day home across the street from me that actually is kind of like that. Do you want to provide for those types of home occupations in your land use bylaw? And do you think you have any going on today? I suspect you probably do. You might not even be aware that they're happening.
Yeah. No, I think we do. And I think we need to cover that because Airbnb, that kind of thing, I know for sure we have at least one. And I think we need to clarify what our expectations are.
Airbnb is a special type of different thing that we will talk about as well. Allison, can you make sure that we do have a conversation about that one in particular?
Okay.
Yeah, I just also wanted to point out here that, so there's within the residential districts, minor home occupations are identified as a permitted use and major home occupations are identified as a discretionary use, but they're actually not defined. The only definition that's included is for home occupation. So that's one thing that we'll want to clarify in the land use bylaw, is to make sure that we're adding in definitions for those things. So it's very clear what a minor home occupation is versus a major home occupation. And then just making sure that there is an existing section in the general regulation section for home occupation, that everything is consistent. So there'll be a little bit of double checking on MPS's behalf to make sure that everything connects well together there.
Yeah, that's our big problem with our current one.
Yes, yeah, I don't know. It becomes difficult to enforce your land use bylaw if you can't point to provisions in the land use bylaw that explain specifically what it is that we're talking about and how it's regulated. So we will be, one of the goals I think for this project is to make sure that the document is an enforceable document too. Otherwise it's not very useful to you, and it's very frustrating for people in the community too. So, all right, we will address both of those. We'll tidy that up, and I think it makes sense to leave the minor as permitted because they're virtually not, they're virtually invisible. And then the major as discretionary. So you have the ability to say yes or no to them, depending on whether or not they're appropriate in the location that they're being proposed.
Great.
Sounds good.
Okay. So then we'll go through the processing and notices section of your land use bylaw and just make sure that everything is consistent with the more recent amendments to the MGA, the Municipal Government Act. There have been some changes to the process that affect notification. The time frame, I think I went up on my soapbox and probably ranted about this at our last meeting. The 20 days we have to deem an application complete, and then how we go through the decision-making process. And then we will provide some additional clarification about what the types of application requirements might be and what the triggers would be for asking for that additional information. So things like a geotechnical report, an erosion and sediment control plan, or a lot grading and drainage plan, landscaping plans, real property reports, slope stability analysis, or wetland assessment. And these are normal things now that we have to ask for in some situations in order to be able to clearly determine whether or not a site is suitable for the use which is intended, and to protect people, right, from doing development on hazard lands that at the end of the day we allowed occur in an area that was unsafe. So I know that we have started applying these requirements at time of applications, that we have the type of information that we need, but it's hard to do that if they're not specifically spelled out or identified in the land use bylaw. So we'll add them, we'll add definitions for these types of reports so people know what to ask somebody for a quote for, and then we'll identify what the triggers would be. So we're not just unreasonably applying or requiring people to spend more money for no good reason. There needs to be a good reason to ask for these things too. The other, I guess, absence, I think, in your existing land use bylaws, we don't have a lot of provisions that identify what types of conditions might be applied with an approval. And there has been some recent legal, what do you call it? When the lawyer gives you an opinion, legal opinion, there we go. For municipalities that indicates that we need to identify what the potential conditions will be when we issue an approval for a development permit or for a subdivision decision too. So all of this information is upfront. So we'll add that into your land use bylaw, and then we'll flag that for review with council when we have the draft prepared. The next section, which would be a new section in your land use bylaw, pertains to the subdivision process. I don't know why the older land use bylaws are silent on subdivision. It's kind of a funny absence, in my opinion, but many of the older land use bylaws don't have any provisions at all that talk about how subdivision will be handled within the municipality. We just go directly to the Municipal Government Act and the Subdivision Development Regulation, which, unless you are MPS or your administration or council because something has happened that shouldn't have, nobody ever goes to look. So this will just bring that information into your documents so that your community has a little bit more information about what happens with those processes. That makes the document more transparent and the process information more transparent, but it's also necessary now too, with the requirement to, I guess, deem an application complete or incomplete within 20 days. There's a provision in the MGA that identifies or requires municipalities to include in their land use bylaw information about what form the notice of an incomplete application will be given to an applicant in, and it has to be identified in your land use bylaw. So we've got to add some stuff anyway pertaining to the subdivision process. We figured we might as well make it a complete section.
Would that section also include consolidation of lots?
No, because you do not need subdivision authority approval to consolidate lots.
Okay, thanks.
Yeah, it's a separate process. Yeah. I don't know, has that happened very often in your municipality?
Oh, mine was.
Yeah, well, there's several.
Okay. Yeah, there's a couple of different ways you can go about doing that, but those processes are the information about how you do that. Part of it is in the Municipal Government Act, and part of it is in the Land Titles Procedure Manual. They're different. Yeah, and not regulated directly by the municipality unless it's done by partial plan cancellation bylaw. So we're generally silent on that in land use bylaws because it's just a slightly different process.
So what about after consolidation if they want to reverse the process? because what happens, it saves tax dollars. And if they want to reverse the process, then, you know, we have a problem with that. And how do we address that component?
It depends how the consolidation was done originally. So, and the age of the plan, it's kind of a silly thing. If it was a pre-1950 plan and the consolidation was done like directly through land titles, they just applied through land titles to consolidate the lots.
Yeah.
And to separate them, they do need subdivision authority approval. And that's because prior to 1950, land titles registered new lots without subdivision authority approval. If you wanted to register a plan directly through land titles, you could do that, and the municipality wasn't involved directly. After 1950, the legislation changed so that for a new subdivision plan to be registered with land titles, the municipality had to sign an endorsement sheet. So if two lots are consolidated after 1950, they were on the same plan and part of the same block, and you want to separate them, you don't require municipal approval to do that. You can do it directly through land titles. If you did it using a partial plan cancellation bylaw or a survey, it's different, then it's a full subdivision. So that's a long answer. None of it is really straightforward. It's one of those, it depends. Some of them we can control and some we can't.
Yeah, well, I guess what concerns me is the resident has saved on tax dollars, and can the village recover those monies if they choose to reverse the process?
That I can't answer. That one's really clear. You cannot.
Okay.
Not the answer you want.
Okay, just checking.
Yeah. So because some of these things are a little bit tricksy, and the municipality is or is not involved, depending on a whole bunch of different factors, consolidation and then reseparation of lots or re-subdivision, depending on those things, is all a little bit separate. Yeah. Yeah. Okay, then the next bit here just deals with appeals. We'll expand that section to include some information about subdivision appeals because it's just missing right now. And then we'll update it to make sure that it's consistent with the new MGA requirements for subdivision and development appeal board members, the appeal applications, hearing procedures, and decision making. So a lot of this information that we're putting into the land use bylaw doesn't change what the processes are now, because they're very specific to the requirements in the MGA. It's just bringing it forward into your documents so people know what's going on and how it affects them and what they can do in relation to these processes. Then we get into the actual regulations. So all of that stuff is just the administering of and how decisions are made and how decisions can be appealed and all of those pieces. Probably we should have had in there too a land use bylaw amendment section too, because I think we can elaborate on that a little bit as well. Hey, Allison.
Oh, we have a separate section in the proposed structure. I just didn't include a slide.
Gotcha.
We have a lot to talk about. So I was like, maybe that's something we could talk about when we do the draft LUB review. So
fair enough. Fair enough.
Their land use bylaws, they're just so comprehensive. They take a lot of time to talk about.
And they're nowhere near as fun to talk about as MDPs. They're really boring, but they're really, really, really important. Yeah. So in your general regulations section right now, there are a number of things that you've already got covered. The things that are working, we won't mess around with, but the things that we think that need to be substantially revised or are missing entirely, we'll provide you with some provisions for those. Allison, some of these here are in blue with question marks. Are these because we're wondering whether or not the Summer Village would like to regulate them separately? Mm-hmm. Mm-hmm. Okay. So the only reason you would regulate, say, boathouses differently than other types of accessory buildings are if you want to limit the types of development that you allow in a lakefront yard, which I think you should do. Some municipalities, summer villages, don't allow any development in the lakefront lodge or lakefront yard, and some municipalities will allow a boathouse to be developed in the lakefront yard. Now, we have to be really clear about what we're talking about when we're talking about boathouse. We're not talking about the historic boathouse that's built into the bed and shore of the lake, because those are those are not a thing of the future. Those are a thing of the past. We're talking about a small accessory building, quite possibly that is movable, but doesn't have to be, that's located in the lakefront yard to store aquatic equipment and, you know, life jackets and things like that, and kayaks or whatever. In many of the summer villages we worked with over the last little while, there has been a desire to allow a structure like that in the lakefront, because it can be quite a ways from the front yard to carry all of that stuff for the grandkids or the kids to utilize when they're playing on the lake. So we wanted to put that out there for you to see whether or not that's something that you have right now or you do allow in your lakefront yards, and whether or not we need to continue to provide for that moving forward.
Yeah, so the boathouse on Bed and Shore is not acceptable. So I guess in the ones that have it, Jane, are they like defined 10 meters back, or how do they regulate if we do allow that?
Yes, we would require a development setback for them as well.
Yeah.
So that they're not, you know, in the Bed and Shore. Are there any of those built into the Bed and Shore boathouses out on the lake right now in the community?
There's a few from way back.
Yeah.
And Jane, I should note that the way that the way that it's worded in the boathouse definition is that it specifically refers to boathouses that are designed in such a way as to permit the direct removal of boats from the water to the structure. So if that's something that we want to go away from, then we will also need to amend the definition of boathouse as well.
And I think we do. I don't think that Alberta Environment is super supportive of allowing those types of structures to be built into the Bed and Shore anymore. I have heard of specific situations in the last little while where they've allowed one to be renovated. But it was a situation where they felt like the renovation to the boathouse would have a less negative impact on the lake than pulling the whole thing out.
Yeah.
So I think we do need to just clarify that what we're talking about is not that. It is an accessory building for the storage of watercraft, and somebody throws their lawnmower in there, we don't really care. But the purpose of it is to include things that you would use when you are enjoying the lake, and it has to be set back a certain distance from the Bed and Shore.
Yeah, what I would not want to see is a rail system going into the water, headed to and removing the boat with that rail system. Separate, I think I could understand that, but I also defer to Graham and Liz. I think that's something we have to discuss.
Another piece of it for me is, of course, it would be specific enough that it would stop anybody putting a lakeside washroom or even taps or something, that the water is going to run back into the lake.
Yes, we can add those provisions.
Okay.
I'm in favor of having a lakeside shed, as you mentioned, for the storage of boating materials such as kayaks or life jackets, because it is a long ways to haul that stuff up and down. And I should probably point out that there are currently a lot of lots that have that existing shed on them. Yeah,
I think it would be, although we're trying to, you know, minimize impacts or the percentage of the lakefront that is covered in non-permeable surface. That's really what we're trying to do. We have to think about doing this in ways that's not going to be so negatively impactful in the way people use and enjoy their property that it's going to create problems. So I think there is a compromise there. We can do this. There's a counselor down on Pigeon Lake, a gentleman who's part of the Watershed Association down there, that very graciously sent us some pictures of a shed like this that he developed on his property. That's pretty cool. He designed it in such a way, he put eaves on the structure so that it would catch the runoff from the roof. And then he built a little rain garden beside it that the runoff from the roof from the little structure runs into, gets filtered, and then goes into the lake after it's been filtered through his rain garden. And he set it up so that water coming down the lot can pass underneath the structure too. So it's almost, you know, he's done everything that he can in terms of design for his little building to minimize and mitigate potential impacts from that non-permeable surface cover too. So we will put provisions into the land use bylaw that allow for this kind of a structure to be built in the lakefront yard, and then we can add some of those design requirements or mitigations to try and minimize impacts on the lake as well. It would not retroactively apply again to those structures that are already there, that are allowed to be there, as they had development permits, or, you know, we're underneath that minimum threshold for requirement for development permit. But it would be a moving forward sort of thing, and then we'll flag that for discussion with council and administration, and also with the community when we get to the engagement part of the project too. Does that sound okay?
Yeah, great.
Yeah, that sounds very fair.
Okay.
I like that
Excellent.
word.
Okay, so the other notes we had here for council were to review the maximum height regulations for accessory buildings in relation to the storage of recreational vehicles and the development of a garage suite or guest house. So Alison, do you want to talk a little bit about that? And then we need to have that conversation about accessory buildings on vacant lots. Yeah.
Mostly it was just in relation to double checking in the sections that we talk about suites, and then our section about accessory buildings, making sure that we don't have any inconsistency in height requirements. That's kind of what my line of thinking was there, because currently you do allow garage suites, which is essentially a guest house that's built above your garage. So we just want to make sure that whatever height requirements we have for that, we're consistent in both of those sections. The part about storage of an RV, I added that in because I wasn't sure. Do you have a lot of residents that store RVs within their garage in the summer village, or is that not really something that happens? Do you know?
I don't think I'm aware of anybody who actually stores their RV inside a garage.
Yeah. So maybe that's not something we even need to speak to, Jane. I'm not sure if you have any.
I stand corrected. There is one on our street that does put an RV inside his garage. That's a corner lot. They have two garages. One is a double garage and the other one is fairly tall for their RV.
What would be the interest of the village in whether or not they store it in a garage?
The only reason that we ask that question is because in order for you to store an RV in a garage, generally it has to be quite a tall garage. So it may, yeah, impact the maximum height you allow for a garage.
I see. Good.
Does the height restriction, Allison, I heard you say that you could have a suite above the garage. That is kind of a bit of news to me, which I think we should allow. But I just want to make sure that we're consistent, that if we're allowing them, that the height is the proper height to be able to do that.
Yeah, so right now, let me just check my notes here. I believe the maximum height of any accessory building, sorry, I just got to get to that section here. Where is it? So the maximum height currently is 9 meters for any accessory building, but it also cannot exceed the height of the main building. So those are the two provisions regarding height for accessory buildings. So if somebody does want to build a garage suite, the maximum height would be 9 meters or whatever the height of the main building is, which is the dwelling.
Well, that would restrict a lot of people from putting a suite.
Yeah, so if you have for example, if you have a 1-story cabin,
yeah,
you wouldn't be able to put a guest, the way that it's currently worded in the land use bylaw, you wouldn't be able to put a guest house suite on top of a garage because you're basically adding another story, and that would exceed the height of the main dwelling.
You know, that seems overly excessive to me. I can say that in days gone by, when things were done through council, we got a variance permit to go up to 18 feet height on the garage building. And so there is a suite up there, which was approved at that time. But it seems to me, I mean, there are lots of one-story cottages that would be very limited then by that kind of restriction.
Yeah, I agree with you, Liz. I think we need to review that one little section that says can't be higher.
Yeah.
I would agree with that. I think we need a little more discussion on the height allowance. I was not aware that it could not exceed the height of the cabin. As I do understand though that suites over a garage cannot have kitchens in them. Is that correct? You know, offhand?
I'm trying to find a definition for secondary suite and I can't find one. Is
Maybe-
that another one of the absences?
I have a slide a little bit later about secondary suites, just because we're talking about this right now. So Jane, I'm wondering if we should just skip to that slide and then we can come
Yeah.
back to where we were.
Yep.
Does
Sure.
that make sense? So I'm not sure exactly where it is. So, and maybe Jane, I can kind of take this on because it's a little bit complicated. So technically, the land use bylaw includes a section in the general regulations about secondary suites. And the way that they refer to secondary suites is they're calling like a suite that's within your principal dwelling. So that's what you see in the bottom image there. They also include garage suite, which is the one that I just talked about, where you have the suite above your garage, and then a guest house. And all of those are identified as a secondary suite. But traditionally, when we're talking about a secondary suite, we are referring to a suite that is within the principal dwelling. So I think what we need to do is amend the definitions. And technically, secondary suite isn't actually included as a definition. It's just explained in the general regulation section. So what I think we need to do is we need to define what a guest house suite is, what a garage suite is, and what a secondary suite is. And then include some additional clarification about what types of facilities are allowed within those suites. So right now, I believe the only definition that we have is for a guest house. And that says it may contain sleeping facilities or additional facilities. So Jane, I don't know, could you interpret additional facilities as a kitchen?
I would. I don't know if that was what was intended, but because it doesn't specifically exclude kitchen facilities, in my opinion, you could put a kitchen in.
Well,
So-
you know, going back to aging in your local area, I think if we're going to allow suites, that a suite also includes a kitchen, and whether it's above a garage or whatever, but again, that's one opinion.
See, I think like back in the day when I applied for mine, we couldn't have either bathroom or kitchen facilities in these over a garage suite. But I honestly don't see the point in that. As long as your bathroom in the suite is hooked up to your septic system, I don't see any reason to prohibit it.
Yeah,
Okay.
and I don't interpret your existing bylaw as prohibiting it, but that's 2015. So
Okay.
sorry, Graham.
One of my concerns with the kitchen in it is we're going to end up, in a sense, with multiple principal dwellings on one lot, which I think could be a concern. So what's your thought on that?
So that is the issue. One of the ways that we can, I guess, limit or minimize, just from the perspective of the appearance of there being two houses on one lot, is to restrict the area that of the suite. So it has to appear, it has to be smaller than the main dwelling on the lot. It has to be, otherwise it is the main dwelling on the lot. So that's something we have to be very careful about. The other issue, and the reason why some summer villages do not allow cooking facilities within suites, is that they can become, it makes it much more, they can be rented. So if in communities where they don't want to encourage Airbnb or those sorts of things from happening, the easiest way to do that is to pull the kitchen.
Oh, yeah.
Yeah, I can see that.
Yeah. So that's something we probably should flag for engagement with the community too. As soon as the kitchen goes in, it's very difficult to enforce how the unit is being used.
Okay. Point taken.
And then the reason that we say your accessory buildings can't be taller than the principal dwelling, the reason we do that with land use bylaws, just from a design perspective, is that sometimes they look quite funny, because it can create, I guess, the appearance of that accessory building being more prominent on the lot than the principal building or the dwelling. Because it's bigger, it's taller, and it can also create shadowing issues on the adjacent properties because it's a much larger structure in terms of height. So do you have any of that going on right now? Do you have any accessory buildings that are taller than the principal dwelling? I guess Liz, you maybe do, hey, on your lot?
Yes, yes, I do. And that was a special approval or a special, what do they call it? Variance.
Yeah.
That time, that was 2006 or so.
When you look at it, from the front, are both of the buildings at the same elevation on the lot? Do they start, like, the ground elevation, is it the same?
Yes.
It is, okay. And how big is your lot?
Well, I have 3 lots that are consolidated and
Oh.
no neighbors beside the larger building.
Right, okay, so there is no potential for shadowing issues or any of those things on your particular property because of the
That's
scale.
right, yeah.
So that's something that's come up in other communities that we've worked with, especially when the lakefront lots are a little bit smaller. If you allow the accessory building to be tall, it can feel very overbearing for the neighboring properties and create shadowing issues on those lots. So
Yeah.
I'll leave that with you guys right now. And in your situation, Liz, like that's the perfect scenario where it would make sense to grant the variance, because all of those things that we're trying to regulate against, there's no potential negative offsite impact.
Yes, that's right. That was our argument at the time that we were looking for the variance.
Yeah, and it might be the sort of thing where that's how you want to leave it, right? If some of those lakefront lots are narrower lots, allow the applicant to ask for the variance so that they can demonstrate that they're going to minimize or mitigate those potential issues that can come from that additional structure on the lot through design in some way. And there's different ways you can do it, but.
And in our current structure, that wouldn't be council giving the variance, that would be the development officer, right?
As it's currently written, it would have come to MPC, but I don't think they were.
I really don't think that should be a political decision.
Yeah, I agree. So
Yeah.
with what we're proposing, it would all be the development officer.
Yeah, okay.
Okay, we will flag that one because I think we should
Okay.
have a conversation about that too. And maybe when we do the engagement piece with the community about that, we can try and get some pictures of a couple examples of what this could do.
Yeah. Yeah.
They're one of the communities that we're working on a land use bylaw right now down on Sylvan Lake. The structures that are going in that community are huge. Like they're very, very large cabins. They're much larger than my house in the city. And then the accessory buildings, the garage suites are going above 3-car garages, and they're quite large too, and they're still smaller than the cabin. And on adjacent properties where there is the original cottage that's 1-story log structure or something like that, the massing of the new buildings is becoming like it's a real problem. So I want to think about all the potential outcomes here and make sure that we're not going to open the door too wide and create an issue for, what your existing character of your community is or what you want to be moving forward.
Jane, maybe what I can do is add an action item for us to see if we can do a bit of research on other land use bylaws and see how if there's other summer villages that have dealt with this and what kind of regulations that they've included in order to ensure that if there is a garage suite that's taller than the main dwelling, or overbearing on adjacent properties, like what kind of regulations are in place to minimize those impacts?
But the qualifiers have to be the design mitigations. Yeah, for sure.
Yeah, so, and then we can bring that back in the draft land use bylaw for council to review.
Yeah,
Yes.
good idea.
Does that sound good to council?
Yeah, good
Okay.
idea.
Yes,
Okay. All right, then we will do that. The next one we had flagged for you were CCANs. Your current approach in the land use bylaw is to only allow a CCAN as a temporarily during construction, so that people have a place to store their construction materials. Are you comfortable with that moving forward?
Yep.
Okay.
Yeah, I guess. I think our problem is enforcement of removal of the thing after whatever end date it's supposed to have.
Are they hanging around? Are they?
We don't have a lot of them as far as I know. Graham, Bernie, you probably know more. But
no, sorry, Liz, go ahead.
yeah, I think we don't want them. We don't want any possibility of them hanging around.
Yeah.
I was aware of 2 of them in the village over the last season. And Tony had looked after the first one. It was gone. That was on Golf Course Road. There was another one that was dropped off on the other side of the village. I don't remember the exact street. And Tony was looking into that one. I don't know what's happened to that one, if it's still there or not. But
It's
Tony
still
does
there.
address it fairly quickly. Okay.
Okay.
But
So, yeah, it's-
basically, we don't want them on lots other than possibly for construction.
Okay, then we'll leave it as it's written, and then Tony will be able to apply that as a condition on the permit, that it's allowed until, 30 days after lockup or something like that of the new structure, and then it needs to be removed to the satisfaction of the development officer. And then Tony can do the enforcement. Poor Tony.
Yeah.
Okay, hot tubs. Do you have a lot of hot tubs? And if you do, where are they? My guess is that people are putting their hot tubs, if they have them, on the lakeside instead of on the roadside. Is that correct?
Guilty as charged.
Yeah, just like trying to imagine enjoying your hot tub on the roadside of your property. I really can't imagine an enjoyable situation like that.
Yeah.
So I think we need to provide for these. Maybe, and I don't know how we deal, it's the changing of the water, right? And how that water gets dealt with, so it doesn't just dump into the lake.
Yeah.
But it's going to be what it's going to be. So maybe we let the watershed folks try to deal with, the best practices relating to caring for your hot tub.
Yeah.
Yeah.
Do we currently need a permit to install a hot tub, or is that one of those things that doesn't require a permit?
I bet you it doesn't say in your current land use bylaw.
Sorry, I was talking and I, again, was muted. The land use bylaw is completely silent on hot tubs. They're not mentioned at all.
Yeah. So I think do you need a building and safety codes permit for a hot tub? I think you might, because they have to be either have a cover that locks or be in a fenced yard with a fence that locks, just like a swimming pool is my understanding. And it's just a safety issue, right? You can't have an open.
I wasn't aware of that for hot tubs, actually. I didn't think there was much regulation around them. Swimming pools, I could understand, but you would need to get some permit to connect to the electrical, I would think.
Yeah.
The rest of it is just a garden hose to fill it.
Graham, we'll look into it, because I can't remember if they also get pulled into that building and safety code requirement for having to be secured. But I can find that out quite easily, and we'll bring that back to you.
Yeah.
I guess it depends how they're being set up, right? If there's the structure around them, or it really depends how they're put on the lot. That's the bigger issue, and where they're located on the lot.
Yeah. I think the setback is important. Mine, so for example, mine is built into my deck in the front of my lakefront property.
Yeah.
But you also need to have a substantial, like a concrete foundation, otherwise it moves around. So maybe we need to ensure that they're properly installed. You can't put them on bare ground. They'll just go up and down and sink, basically.
Well, and there's hot tubs and there's hot tubs too, right? There's those portable ones that people buy now.
Yeah.
And those sorts of things. And we don't care about any of those at all. But if it's something that is, you know, part of a permanent structure, I think that's something that we do care a little bit about.
Yeah, I agree.
Do you have any information on how other communities are handling that? Is it a permittable item in other areas, or do they all require you permits? What do other places do?
We have been including them in summer villages as something you require a development permit for. And it's for those reasons, right? Is if they're going to get put on or into a deck, or a structure is being built, you know, with a gazebo above it or something like that. We want to make sure that they're within the required setbacks, and they're engineered properly. So I haven't, you know, in the last year distinguished between the different types of hot tubs. That's something I'm just thinking about today, having seen some recent information about these portable hot tubs, the inflatable ones. So maybe we need to clarify what we mean when we're talking about that, if we're going to require a development permit. But we can bring that back to you too, Graham, what some of the neighbors are doing.
Okay.
Because some of these hot tubs have a substantial weight to them when they're filled, and I have seen some, not in the village, but I have seen them, people just putting them on their decks, on top of the decks with no structure underneath, just the deck structure, and it just looks like trouble waiting to happen.
Yeah.
Absolutely. Yeah. Okay. Well, we'll bring a bit more information and we'll flag this one too. Allison, is that what you needed for that one? Yeah. Okay. Okay. Dwelling units on a lot. So I think we just need to clarify, because as we are clarifying the provisions for what types of suites you allow and how many suites you allow, we'll need to revise this section to accommodate that. So I think what we're recommending moving forward is that you allow a principal dwelling and up to a maximum of 1 suite on a lot, probably. But we're going to have to come back to this conversation when we're talking about RVs too. Because I know you have RVs that are used as the cottage or have historically in some instances, and all of those are types of dwelling units, right? They increase the density on the lot. So do you want to provide for a dwelling and a suite and an RV, or do you want to provide for a dwelling and an RV, or a dwelling and a suite, and then, you know, have a maximum density, and people who own the lots can decide what it is that they want to do? I think that's something we need to maybe have a conversation about.
I agree.
Yeah.
Yes, here too.
Okay, otherwise it just grows and grows, right? So for our next meeting, we'll bring back some recommendations and some different options, and then we can talk a little bit more about how you want to deal with it. Fences. So we'll go through the fencing requirements and just make sure that they're clear. And then we'll add some figures to explain what we're talking about when we're talking about maximum heights of fences. Because you do have some lots within your community where there are significant changes to the topography, right, that would affect fencing. I can't remember right now, are you guys allowing fences in your lakefront yards, or are they restricted? Are we restricting the height? Some summer villages will not allow a greater than 3-foot fence in the lakefront yard so that the views are unobstructed of the lake.
Yeah.
Jane, can I jump in here? Because I
Yeah.
I looked into this, and part of it was, council, I'm not at when I came to your February meeting to talk about the survey results. I apologize, I can't remember which councillor flagged it for me, but was concerned that the current regulations for fencing is inconsistent between what's required, what doesn't require a permit, and what does require a permit. So I did look into the regulations. So the way that it is worded currently regarding fences, so for fences that do not require a development permit in the front yard, it has to be under 3 feet, but it does not speak to whether that is a front yard in a lakefront yard versus a back lot. So as I interpret it right now, any front yard, whether it is a lakefront yard or a backlot front yard, you can build a fence that is 3 feet or less without requiring a development permit. Now, if you want to build a fence in the side yard or the rear yard, you can build a fence without a permit if it is under 6 feet. So that's what you can do without requiring a permit. Now, when we get into the requirements about fences within the general regulation section, and I think this is maybe where it is a little bit difficult to interpret. So you cannot have a fence that is higher than 3 feet for the section of the fence that extends into the front yard beyond the frontmost part of your building or your principal dwelling. So wherever your house is, whatever the edge of your house closest to your front property line, from that point, you cannot have a fence that is higher than 3 feet. And it doesn't matter whether it requires a permit or not. It's just your fence has to be 3 feet or less in the front yard. Now, if you want to build a fence like for your side yards or your rear yards, you can build a fence that is higher than 6 feet. Basically, from that front point of the front of your house towards the back, you can build it higher than 6 feet, but it does require a permit to do that. Does that kind of make sense? I was saying to Jane, this is something that I think we might want to have some drawings for to illustrate what this means, because when you're reading it, it's not the easiest thing to understand. But the long story short, in your front yard, you can have a 3-foot fence, and that's it. And it doesn't require a permit.
I have a comment about that. I don't know what the answer is, but it's hard for people with animals to not be able to go higher than 3 feet in the front yard. I don't know what the answer is, but for instance, dog control or whatever. I think we should discuss that along with it.
If I may, I think I was the one who brought up the questions about fencing, and I don't have the pages in front of me, but I know in the front part of the existing land use bylaw, it says items that do not require a permit, and it just says fencing. I didn't recall too many criteria. And then later on in the document, it states items that do need a permit and lists fencing.
So if I can jump in quickly. So the section in the general regulations is not necessarily saying that you need a permit for the fence. It's establishing the rules about fences. So it's a little bit confusing. So when we say you can build a fence in your front yard if it's 3 feet or under, and that doesn't require a permit, but then the also says that you can just never build a fence that's higher than 3 feet in your front yard.
Okay.
Yeah, it's a little, I understand it's kind of
it's confusing.
Yeah, this is why sometimes when planners are reviewing the regulations, I always kind of think if I have trouble interpreting a regulation, that probably means that it would be difficult for somebody who's not a planner to interpret the regulation. So I guess in terms of our conversation is if council wants to allow higher fences in front yards, because currently the maximum is 3 feet.
I think one of our discussions somewhere in the last couple of years was what if we allowed higher fences in the front yard, for example, for animal control, but they were out of a material that doesn't obstruct the view, like a wire, whatever you call that fencing that you can see through. That was one of our discussion points at some point.
Yeah, I agree with that. That's why we kind of a discussion anyway to allow up to a 5-foot non-obscured fence, such as chain link for pet owners and stuff, because the 3-foot fence really wouldn't do the trick.
In the lakefront yard. The other question I had, because I can't tell from the definitions of the yards in the land use bylaw, is on a lakefront lot, do you have 2 front yards or do you have a front yard and a backyard? On the road side, is that the backyard? And if it is, are you allowing up to a 6-foot fence right up to the property boundary? Because that would look like a fortress on that side and could make it difficult from a, traffic safety perspective, as people are entering and exiting the property with their vehicle. So, I mean, that's the reason we normally do restrict fence height on the roadside.
Yeah.
So there's something there that's unclear too, to me.
It is, it's confusing, especially when you get into lakefront, because I would consider the lakeside to be the front side. But on the same thing, I don't believe in fences going across the lakefront.
Yeah.
I would prefer not to see them. I mean, part of the logic to not allowing sheds was for the aesthetics and of the village. I don't agree with putting a fence across the front either.
Okay, well,
Yeah, into this thing is, so where are you putting this 6-foot fence? Either it runs all the way to the road or it runs all the way to the lake, and it's not clearly defined.
yeah, and there's negatives in both situations. Yeah.
Yeah, I tend to agree with lakefront property. Like, I think we have to define which properties we're talking about, back lots or lakefront lots. I do not agree with any kind of fencing across the front of a lakefront property. In terms of animal control, I still believe, Liz, that you can have the 5 or 6 foot fence. I don't know why we'd allow more, why it's even open to more than 6 feet anywhere on the lot. But in the back, you can maintain your animals from the front of the house back. Because I like the provision that it be no more than 3 feet in front of your house. If it's a back lot, it permits a view for the other landowners. If you allow a 5 foot fence, but chain link does help with the viewing, right? So yeah, more work.
Sorry, I apologize. I just want to clarify. I misread. You can't have a fence higher than 6 feet in your rear yard or your side yards.
Oh, okay.
I misspoke there. My apologies.
Okay, so we'll bring something back because there are different issues on the front and the back.
Yeah.
Well, or the front and the front, however we want to look at that of the lakefront lots. And I could see the fences being a bit of an issue, and maybe we'll do a little bit of follow up with Tony too, to see what he's been allowing or what he's getting demand for, and then just bring that all back to you.
Yeah.
Okay.
Is it possible at some point, and I'm just throwing this out there, to use part of the definition as the roadside part of the house or the lot rather than the front or back?
Yep. Yeah, we can incorporate that in it. Roadside and lakeside are a lot easier to understand, right?
Yeah.
Yard. Yeah, we'll figure that out.
Yeah, the definitions for right now are a bit vague in terms of front yard and rear yard, as Jane already pointed out, and I'd flagged that as something that we need to clean up those definitions and make it a more clear for people what those are actually referring to on a lakefront lot versus a back lot, so that it's really clear for anyone who's reading the land use bylaw to figure out what's my front yard.
Yeah. All right, then the next one relates to lot grading and drainage, and I think we need to make it really clear that there'll be an expectation for lot grading and drainage plans for new construction. If you're bringing in a portable shed, we don't care. But if you're building a big new garage or a new cottage, then if you're doing any kind of construction on the lot that will substantially impact the drainage, then you should be providing a lot grading and drainage plan, and that really should be the trigger, right?
Yeah.
So don't care about your gazebo, don't care about your shed. We do care about things that are going to change the way water moves on your lot.
And we have outstanding issues from long time of people expecting the village to fix their on their own lot, their drainage problems that were never addressed at the time they built.
Yeah, ongoing mess of things, and not the municipality's responsibility, but if we ask for these things and we have them in the files, and people do things that are different than what that was approved, it makes it a lot easier to say, no, this is something that you need to correct.
Yeah.
So we'll put some things together for that, and then we can have a chat about it.
If I may, I also think that the development officer is going to have a lot of leeway in that, because when you're developing a new lot now and you have two lots that were developed in the 50s beside you, that lot plan is not going to be clearly defined, or you're just going to start flooding the other two lots. And that's a really touchy one for everybody, I think, because there was no drainage here in the beginning, and now with the new lots coming in, they just seem to be flooding the neighbors.
Yeah, and they cannot do that. So we have to be really careful about what the requirements are there. One of the things that we've been doing is requiring new construction to tie into the existing elevations on the corners of the lots. And then if you want to build up your property because you want to put in a walkout basement or something like that, you may have to put in a retaining wall, and you may have to put in, a culvert or something to move the water in the direction it needs to go. It cannot fall off of your lot into your neighbor's yard. Even if your neighbor's cottage is in a hole, you still can't run the property, increase the amount of runoff coming off of your lot into your neighbor's property.
Right.
So it is going to require a little bit more survey work and design work when the new construction happens, but that's our responsibility to make sure that we're not inadvertently creating issues for a neighbor.
Great.
All right, parking. So we're going to revise the off-street parking requirements just to make it a little bit clearer and just review them. You do not need parking requirements for industrial uses, or well, maybe you do for institutional uses, because you do have some municipal land, but we'll just clarify those pieces. And you may, moving forward, have a commercial use or two. We'll see what happens as the golf course development, all of those lands occur. So I think we need to provide for that in the event that something happens there. And then one of the things we'll talk about, I think, are bed and breakfast developments. Do you have any bed and breakfasts in the community today? I think they're defined, there's provisions for them, but they're not identified as a permitted or discretionary use.
Yeah. I don't think we do, but I think it's good to add that in.
Yeah, I don't see a whole lot of harm in having a bed and breakfast. If there's somebody on the site, right, that is managing the site, then it's kind of a nice option to have, especially if you have, a wedding or something in the community, then you've got some accommodations you can provide locally with minimal offsite impact. Yeah. And then we'll just provide a little bit more clarification about what we're talking about when we're asking for people to provide parking stalls, what those dimensions should be. All right, recreational vehicles. So in this section, we'll just review and have a closer look at the definitions for temporary living accommodations and RVs and park models and mobile homes and manufactured homes, and make sure that the definitions are clear, so there isn't any ambiguity about their interpretation. And then we'll review the regulations in the residential districts versus a condominium residential or recreation district, and make sure all of that still jives when we put those missing regulations back in. Yeah. Specifically in relation to RVs. So you guys did a survey about this, and you had 75 responses for one of the questions and 38 for the other. So you did get some feedback from members of the community about this stuff. How is it going, the amendment that you approved? Can we have a relook at it and see if we can provide a little bit more clarification about what it is that we're actually trying to regulate and prevent from happening on the lots? What is there wiggle room about it and what isn't there? Like the number of RVs that you would like to see on your residential lots. You must have had some conversations about that prior to making that amendment to your document. Is that a fixed number for now? We'll leave that as it is. How do you want to deal with that?
Well,
I believe it's a fixed number.
Okay, then we will not touch that. Other than in relation to our conversation about suites, which we will bring back to you. If a RV on a lot is being used seasonally, we think it should be connected to power and wastewater at minimum. So we know that the wastewater for that RV is being collected as it should, and there isn't the possibility of a generator running, at unreasonable hours to provide power to that RV.
Agree.
One of the things that I would just like to bring up now is connection to the wastewater system, and there's some confusion on that now is that the RVs, most of them come with an approved wastewater collection system. And I don't think that's what we have in mind for a seasonal dwelling, that it requires an actual tank, an in-ground tank, a pump out tank, rather than the onboard tanks.
Yeah, I think that's something that needs to be clarified too, is that we want a place for that wastewater to go after it leaves the tank on the RV, so that you don't end up with somebody driving down the road and that's where it goes. Because unfortunately that is a thing. So we'll clarify some of those pieces and flag all of that. And then the other bit that I think is really important is making sure there is a dedicated parking stall on the lot. You know, this is where the RV is going to go. It meets the setback requirements for an accessory building. I think it should. And this is where the power and the wastewater connections are going to be. And then when there is an approval issued, the approval is for the stall. It's not for the RV, and then the RV can come and go. And so you're just approving the stall. It's done. Everything is there. And then Tony doesn't have to monitor the comings and goings of RVs. He just has to count the number if there's an issue.
If I may on that too, to expand just slightly on one of my thoughts is we're talking about dedicated parking stalls. I think that also has to include vehicle parking. There are some lots in service now where they're simply parking on the grass. With today's cars, that's not a good idea to park cars on the grass. The possibility of fire is quite high. I think a gravel driveway should be supplied for vehicle parking as well as for the RV pad.
Yes, we didn't spend a whole lot of time talking about that in relation to the parking provisions, but there should be parking on-site parking stall requirements, minimum parking stall requirements for suites and for RVs. Because if you're going to have those additional guests, then they need a place, then you need to be able to accommodate them on your lot. And if there is insufficient room on your lot to accommodate not only the structure or the RV and the parking, then the lot is simply too small.
Yeah.
So that's how we'll approach this. If you've got room on your lot to have these things and it's, you know, you can handle it all within the boundaries of your lot, so be it. It's good. You're good to go. But if your lot isn't big enough to accommodate these things, it can't be designed to address them and have sufficient parking. And I agree, the grassed parking stall is not good. I don't know that we want to encourage necessarily additional hard surface, but gravel's kind of gravel's a compromise, right?
Yeah.
Then we can prevent some of those potential issues, and it's easier to demarcate right on a lot where it's going to be. So we'll put something together for those pieces. We'll flag it. We'll have a conversation about that too, and we'll make sure that gets out to the community for their feedback, because I know this is a tough one. Manufactured homes. Your current land use bylaw includes provisions and districts for manufactured homes, manufactured home subdivisions and parks. Do you want that carried forward? Do you have a manufactured home subdivision or park in your community? That's very urban.
There's nothing districted that way, Jane, but there are 2 districts for it and then sections about it. So I don't, and
think
maybe
we need that.
it was kind of, when I read it, I thought this is kind of strange. It seemed like a section that would have been in an urban like a non-lake urban municipality.
Mm-hmm.
And that's why I flagged it, because I thought it was a bit odd to have.
So you have an RMHS residential manufactured subdivision and an RMHS residential manufactured home court. I don't think you need either of those.
Okay.
Can we pull those districts?
Manufactured homes, and with that, I'm thinking of modular homes. They don't need to go to a special district, do they? Because we've had several installed over the last few years that have just been conventional structures, I guess. So
Yeah, a manufactured home is not a modular home. They're
Okay.
So a modular home is literally one that's like either prefab or parts of it are prefab, and then you construct it on site, but would like essentially, and Jane, correct me if I'm wrong, would look like a single detached dwelling, whereas
Looks stick-built. Yeah.
exactly. And it's very specifically differentiated in the definition section between a modular home and a manufactured home. They're not.
Manufactured homes are the 3-to-1. They look like trailers still.
Yeah, exactly.
Take
So
it
you
out.
talk old mobile.
Yeah, mobiles.
Yeah.
You got it, Graham.
Yeah.
So I think the modular and stick-built should be interchangeable. They look the same.
Yeah.
But the only reason we would leave the manufactured subdivision or manufactured home court districts in your land use bylaw is if you had one or someone had expressed interest in developing one. But because there's nowhere on your land use bylaw map that's in those districts anyway, I don't think we need them.
Okay.
Okay, we will pull those. I'll flag that as well.
Good. Good.
Suites, we had this conversation. Current land use bylaw map.
Oh, yes, I just wanted to provide a preamble because if I recall correctly, the next slides are about the residential districts. So there's a bit of inconsistency right now in the current land use bylaw. So the districts that were created, sorry, I just got to flip to that page here. There's 4 different residential districts, none of which are actually identified on the map. They're all classified as residential.
Which doesn't correspond to any of the districts that you have in your land use bylaw. So I don't know what anything is zoned right now.
Mm.
And I think it's, and Jane, feel free to jump in too, but I think it's unnecessary to have 4 different residential districts. I think we can probably reduce that down. And what we would propose is you have your sort of regular residential, and then you have a large lot residential district for those lots that are larger. And typically what changes then is the percentage of your lot that you can cover on a larger lot would decrease.
I don't even know if you need a large lot district because all of your lots are, very close to the same size. So
it's just really in the north part, the lots that are adjacent to the condominium recreation, probably. And then those would be like the larger lots, probably.
I don't know. You're talking, let me see if I can get my mouse across the screens here. This area right here.
Yeah, exactly.
Yeah, that's the only thing. But
I had always thought that different zoning was for future development and especially into what's marked as the urban reserve, as to whether someday that will ever be developed and what it could be developed into, of course, is up in the air. How difficult is it going to be if that does get developed and we have to start adding different categories at that point?
so they'll have to do a land use bylaw amendment anyway to rezone that land. I'd rather see what they come forward with for what they propose. We could do a small lot and a large lot and just leave it. But you do not need 4. The only place that I work with that has this is Spring Lake, and they do need 4. You don't.
Yeah.
Yeah,
I
that was
agree.
just an assumption on my part. So yeah, I think you're probably right.
Yeah.
And any time that we can eliminate some of these terms or definitions or whatever, that will make it clearer for everybody.
Well, and I don't even know that you have any lots that are larger than 1 acre. So Allison will go through when we're preparing the land use bylaw map and see. I think everything might go into what is currently identified as your R1A. I don't know. And I'll follow up with Tony too to see how he's interpreting that.
Yeah.
And we'll just try to be consistent with what's been going on. But there's something fishy there, so we'll fix it.
Okay. Thank you.
No problem. All right, so that's what we talked about. Do you want to allow for duplex development or any higher density development, or do you want to keep things as they are? Single detached with, the possibility of an RV or a suite and just leave it at that.
Yeah.
Is there any demand for duplexes?
Nothing I've ever been aware of.
Not that I know of. No.
I think we leave it alone then. Let's leave it alone. I don't like increasing your density because you don't have municipal water, wastewater. I think it's high enough as it is on independent systems.
Yeah.
Okay. All right, now we're into other things to think about, and that's our keeping of animals, chickens and roosters and bees, apiaries.
Yeah.
I don't think you want roosters.
No, but I think for the others, I think the potential could be there. We've had a couple of inquiries about chickens.
I do you, I don't know, off the top of your heads, I think I asked you this last time and I've forgotten. No, is there very many people that are in your community full time?
Yeah,
214.
Oh, that's a lot. Okay.
Oh, sorry. Could you say, what did you say, 214?
Yeah.
Okay, I just wanted to make sure I heard you correctly. Thank you.
Then I think we should provide for chickens and bees.
yeah,
And we can set provisions around that to limit the number.
yeah.
You know, just to throw some lightness into this, I recently met and was considering asking to have a miniature donkey.
Oh,
Yeah, where's that fit, under pets or?
oh my goodness. Well, you have a big lot.
Yeah.
Mow the lawn.
How do we control the hee-hawing though?
That might be hard. Don't worry, I've decided against it.
Yeah.
Oh, I've heard that goats are good lawnmowers, but they're also very wily. So I don't think that we, unless council directs us to, will provide for any other types of livestock, just chickens, excluding roosters, and then bees. That is a large full-time population for your community. I think we need to do that. I know that a few years back, this came up as a really controversial thing at one of the lake communities that we were working with in a rural municipality in a county. And the lake people were not interested in there being any laying hens at the lake because it was going to affect the water. And so we actually looked into the amount of phosphorus generated by, say, 6 laying hens compared to how much phosphorus is generated by putting fertilizer on your lawn. Guess which one is worse?
Yeah, yeah.
Indeed, yeah.
So there shouldn't be any issue with those sorts of things. It's just, I guess, good animal husbandry will be required.
Jane, just to clarify, would we recommend, sorry, with the apiaries and the chickens, would we recommend that those be discretionary uses within the district? Or maybe is that something you want to think about a little bit more before we make a recommendation?
I want to think about that a little bit more.
Yeah.
Okay.
I think they're virtually invisible things that happen on lots. I don't know that they need to be discretionary, but they're also things that people have very strong feelings about. So I'll leave that with council to think about too.
Yeah. Okay.
All right, commercial districts, commercial uses in districts. So you have one commercial district and no lands included, but I think that speaks to the information we were provided about in the golf course area structure plan. There was the possibility of there being some commercial in there. So I don't think there's any harm in leaving that one.
Mhm. Yeah.
Okay. And then we'll just leave it with no lands in it for the time being. The Allison here, permitted uses, discretionary uses, is that in the commercial district?
Yes. So
The
I
only
just,
permitted use is a public utility?
yes.
That's weird.
Um,
We may rework that a little bit.
and I listed all the discretionary uses in case we wanted to have a discussion with council about the types of commercial uses that they want to allow, should a commercial district be started in the future.
The
So
way it's defined right now, everything would just be discretionary.
yeah.
Well, we could leave it like that for now. And then if somebody wanted to rezone their property to a commercial district, they could at that time, as part of that amendment, apply to move whatever it is that they want to do on that lot from the discretionary use to a permitted use. And we could have that conversation at that time. It does feel a little bit premature to start planning for that when we just don't know. It's, I think, pretty far into the future. Maybe we leave that alone. Is council okay with that for the time being? We can revisit it.
I'm okay
Yep.
with,
Yeah, I think we leave it.
Okay. Does that make sense to you, Allison?
Yes, I had wanted to flag it just so we could get a bit of direction, so,
It is weird,
yeah.
but I kind of get it in this case.
And then I guess what I'll add to that is we'll make sure that all of those commercial uses are defined. I think most of them, if not all of them are, but we'll double check and just make sure that they are in fact defined.
Yeah, I don't know that we need to add more general provisions right now. I think we just wait. I just don't want to open the door too wide to those sorts of things. I don't think that's the intention. But we should deal with cannabis probably too. So we'll do that and then we'll flag that for council.
Okay.
Urban services. Oh, where should that be? Daycare, school, library. You have your own, you do have municipal facilities, right? You have a shop building.
Shop, yeah, we do.
I wonder if that should be in this district. It currently is not. What district is that in? Let me just go to the next slide.
I think it's in the discretion, it's in the direct control, I think, isn't it? Because it's on the south side of the main road, right? When you come in.
There's a little lot there that you can't see, right?
Yeah.
I think it's in the direct control district.
We'll confirm that with Wendy and Heather. I think if we're going to propose any additional changes to the map other than clarifying the residential districts, that would be the only thing that we do is just put your municipal facility, the public works building, into the urban services district.
Yeah.
Okay.
We may need to expand that in the future too, so we need.
Well, we can leave the use as a permitted or discretionary use in the urban reserve district so that we don't, force you to do a land use bylaw amendment. If you needed to expand that, you could do it when you have time.
Yeah.
But I think that makes sense. Yeah, I do think we need to carry forward the direct control district, Allison, and the urban reserve district.
Yep.
I'll answer that one. Yeah. All right. So your reserve parcels, municipal or environmental, I think they're old, or most of them except in Poppy Place. So they probably just are our designation. They're all identified as park. I think that's good. I think we should leave it like that. The only thing I don't like about that is that as subdivision occurs, as per what's identified in the area structure plan, we're going to have to rezone bits park and rezone bits residential to be consistent. But I'll remember that, and then we'll deal with it at that time.
Okay.
Allison, do you want to handle these ones?
Yeah. So these were a couple of items that were on the list that Heather had given me that council wanted to talk about. So the first one, fertilizer bans. If this is something that the Summer Village wants to do, it's best dealt with in a separate bylaw. So you can establish a fertilizer bylaw and then decide how you want to deal with fertilizers. We would not recommend dealing with it in the land use bylaw. And then regarding fines for the disposing of gray water or black water on the lot or the reserve. And Jade, feel free to jump in, but I think this is best dealt with in your wastewater bylaw. So if you wanted to amend your wastewater bylaw to prohibit dumping of gray water on the lot, you could add that. You already, I believe that the way it is worded, it already, well, it speaks to wastewater, which I probably has interpreted more as black water. So you could amend that to add that in, and then correspondingly you would add something to your fees bylaw. I think, or no, I guess it's not fees bylaw, sorry.
The fines are in the wastewater bylaw, I believe.
Yeah,
so
sorry.
we just have to adjust that. Yeah.
Yeah, sorry. Yeah, so that would be our recommendation. And then regarding the removal of septic fields on lake properties. So I did a little bit of digging. So in the current code right now, the minimum separation distance for fields and mounds from a water body or a water course, so in this case, the lake, is 15 meters. So technically people can have fields, depending on the configuration of their lots, could have a septic field in the rear of their lot.
If it was established before the restriction went into the municipality's wastewater bylaw.
Yes, and so that's the way that we interpret the wastewater bylaw with the amendment that was done. I'm just finding the bylaw is that the bylaw, okay, hang on, sorry here. Outdoor privies or any other system for the disposal of sewage or wastewater on the parcel of land which results in the disposal of sewage and wastewater into the ground is not allowed. And then there's a notwithstanding clause that allows for a septic field that is working effectively to be continued to be used. However, once there's an issue with that septic field, so it fails, then it must be brought into compliance with the regulations of the wastewater bylaw. So the way that, and Jane, feel free to jump in here too, the way that I interpret that is that if their field fails, they cannot build a new field.
That's right. They have to come into compliance. Yeah.
Yeah, so then they would have to install a holding tank, right? So that's how we interpret it right now. If you wanted to require people to remove the septic fields on the lake properties, there's a couple of ways you could deal with that. You could amend your wastewater bylaw to say that folks have to remove their septic fields, and typically what would happen then is you give a certain time frame for them to come into compliance with that requirement. Jane, do you know, like, roughly when they make changes to that, it's like a couple of years? Is that kind of how it works with?
Yeah. It's just to give people the time to have the money to do the thing. It's always controversial, really controversial to do that.
And then your other option is to establish a trigger at time of redevelopment. So say there's a lot that has an existing septic field and they want to rebuild their cabin. You could require that at time of redevelopment, they have to remove their septic field and install a holding tank.
And I would suggest that's the more reasonable trigger, because if everything is status quo and everything stays status quo, then you are a legal non-conforming use, including your system. But as soon as you go to change something substantial on your lot, it would make sense for you to have to bring everything into compliance. So that's maybe the change we would recommend to the wastewater bylaw, is that you're good to go until you do something new. And then once you do something new, it's time for you to deal with this issue.
I guess my comment on that is that I truly believe that a lot of the septic systems are on lakefront properties are beyond their years of legal use, or for lack of a better word. Then how do we deal with those? It's like,
Bernie, do you think they've already failed? Is that what you mean?
yes, I truly believe the majority of them have failed.
Okay.
I'm aware of several that they've absolutely failed. They bubble up brown stuff every spring because the ground is.
Then I think probably what you need to do is see if you can get. Do you guys use Inspections Group or Superior?
Superior, I believe.
Superior, and perhaps someone from like a health inspector, because they if you can get them to come help, they're useful for this. To come out and do an inspection and identify, gather the evidence that you need to say, hey, these systems are non-compliant and they've failed, and then working with them, require them to replace the system. If the systems have failed, they should not be there. It doesn't, lakefront or not, they should no longer be there. But lakefront is particularly bad.
Yeah, AHS isn't much help. Like,
You're having trouble with them.
I'm sorry, but they're not. Unless we do it, it isn't going to get done.
It would have to be a municipal-led initiative. Is that we're going to do this. We're going to do this in the spring. Make sure your system is compliant, because we're going to do an inspection.
Okay.
And we're coming out to do it. And then they would just be walking around with you, but the enforcement action will be taken by the municipality.
Okay. But that'd be separate from this. It's
It's separate from this.
Yeah. Okay.
Yeah. Yeah, for sure. And if you decide you want to pursue a fertilizer ban, Wendy, Heather, I have some good examples of those bylaws. Just let me know and I can float one to you.
Yeah, I would like to see us consider that.
I think that's a good idea too.
Yeah, is there exceptions for gardens? Since I have a garden.
You can do it however you guys want.
Yeah, no.
I know my tomatoes like a little snack, so I get it. So, all right, excellent. Next steps. That's a lot of the preliminary heavy lifting. I apologize. We took up a ton of your time, and as we start working through the details in the draft, they will be long meetings too, especially the ones that are a little bit more controversial, because we want to make sure that we get these things right for you. So our next steps are to prepare the draft with the direction that we received from you guys today, knowing that it's a straw horse. Like once we're preparing something for you to review, and then we'll tear it apart and rebuild it the way that you need it. But it's a little bit easier for you to provide input if I give you something to look at. Yeah. So we'll go through that process, and then once you have a document that you can live with, I think there will definitely be some areas where you need. You're going to say we need more direct input from the community, and that's okay. We'll just get you to identify those areas for us where you want us to very directly flag and ask for input from the community. But once you're sort of comfortable with it, we'll release it to the public. There will be an open house where we can work through those areas with the public and get some feedback from them. The workshop or open house, and then we'll generally what I do with those meetings, and it depends, right? Sometimes we'll get really lucky and people will tune in for these meetings that we have, and they'll be pretty in the know by the time we get to the open house. But generally I approach those open houses coming from the assumption that people are not sure what's in the document. And so I take that opportunity to present to them what it is that we've been up to and what's in the document, and then ask them to take it away and look at it and provide us with their input rather than putting them on the spot. I find people seem to be a little bit more comfortable with that than being put on the spot. We'll compile all of the feedback that we get and bring that back to council and administration, and then we can look at what changes to the document we need to make to address those comments and concerns, revise the draft, and then get it ready for consideration of adoption.
Yeah.
Sound good?
Sounds good. Well, I really appreciate what you've done to this point, and just to explain to the public that this was information for council, and just to get to that first stage, and that we want to be transparent in all of our discussions when it comes to our land use bylaw.
Yeah, this document affects everybody, and it's really important that we get as much public involvement as we can. Generally speaking, a win is a document that people can live with. It's really hard to create a land use bylaw that is perfect for everyone, but we want to get to a point where people understand, what we're doing and the why we're doing some of these things, and they can live with it. So we'll work really hard with you guys and with the community to try and make sure that all that information is shared, and we're addressing questions as they come up, and trying to make sure that all of the concerns or information that were provided by members of the community are shared with council and administration too, so that you have that information. So there's our contact information for any of our folks who joined us to listen in. If you have any questions or comments right off the bat that you'd like to share with us, please feel free to send that along as well, or you can contact administration. I think you know how to get in touch with them too.
I would entertain a motion at this time to accept as information the presentation that we have received on our land use bylaw.
I do have one question.
Okay.
You bet.
We didn't address, or maybe we did, garages on the roadside of properties, which was
yeah,
discussed times in the past, and I didn't see it come up in here. Is that something we're still looking at, or is it something we need to get more discussion on?
Allowing garages in the front yard, the road front yard.
Yeah.
Yeah, I think you have to.
Yeah, I had that flagged. I think that was when we jumped around a little bit. So my apologies, Graham, for not getting back to that. The way that it's worded currently I'm just going to pull up my notes here, in the land use bylaw for accessory buildings. It says that detached garages and accessory buildings are no closer to the front yard than the closest portion of the principal building. So on a back lot, that makes it difficult, because it would be quite difficult to put your garage in the rear part of the lot in some cases, right? Because there's no lanes. And if it's a narrower lot, like access to the rear of the lot is difficult.
Yeah.
And I was trying to think, like, I thought I remembered when I came out to do a site visit that I did see garages in the front yard, but I think it's probably because they're attached to the house, which is different.
There's a few that aren't.
Yeah, so I think Jane, I will have to rework that a little bit.
Yeah.
What's council's feeling on that, right? I guess off the bat. I mean, on the larger lots, they could be in the rear yard, but
Yeah.
on some of those little skinny lots, I don't know.
I
Yeah,
think we should allow them.
I'm in favor of allowing them. just the
Yeah.
basic
I
until-
think we all are, to revisit that, to allow, yeah.
Okay, and we can put some design requirements in there too, to just
Yeah.
make it not feel like it's, it's too bulky or the scaling is too much in the front yard, but still accommodate them. Okay,
And just to clarify, that would be for back lots, because we don't want garages in the front yard of a lakefront lot.
No.
Correct.
Correct.
So
Okay.
we'll just make sure, the reason I say that is it's so that we can make sure that we differentiate that in the land use bylaw.
Only on the roadside, I guess, is what we're discussing on all lots.
yeah, roadside.
Yes, exactly.
Good point, Graham. Thanks.
Okay, thanks for flagging that one.
Yeah.
And then we'll try to bring some diagrams in to show what that might look like too, and then we can have a further discussion.
Great.
Okay, well, thank you, everybody.